with an approximate value of rupees 2,08,500 only. And the work was to be completed within a period of 1 month. Stop. In compliance to the work order, the petitioner executed the work within the time stipulated, and accordingly, completion certificate
1007 Your Lordship.
the commissioner's signs stating that the work had been executed satisfactorily. Stop. It is the case of the petitioner that despite the completion of the work, the respondent authorities are yet to release the bill. It is further submitted that from the records, presentation,
Legal notice, Your Lordship.
legal notice,
Page 20, Your Lordship. 0208-2023.
legal notice 28/2023 to the respondent number 2 and 3. However,
Respondent number 3 and 4.
3 and 4, Your Lordship.
respondent number 3 and 4.
Your Lordship.
Okay.
Your Lordship, page 22, Your Lordship.
Stating that
Lordship saying that the pending bills have been withheld due to a matter pending in the High Court, Your Lordship.
where is that? Which para?
Page 22, Your Lordship. Serial number 3, Your Lordship.
Stop. The legal notice has been replied by the department. The High Court. The bills had not been released.
Yes, Your Lordship. Lordship, what has happened is that the matter was withdrawn, Your Lordship. The incident, the petition, Your Lordship.
No, it's all right. Being aggrieved. The petitioner is before this court. Mr. N. Angami, the Leonard Senior Government Advocate, appears for the respondents. Therefore, no formal notice need be issued to the state. The learned counsel for the petitioner shall, however, serve requisite copies of the writ petition to the learned senior government advocate within
2 days, Your Lordship.
2 days from today. Same with the others.
Yes, Your Lordship.
Same with the others, Gibi, except the work and the amount. All the dates are same. Legal notice, everything is same. Okay.
Lordship, the letter number for tax clearance and
That's all right. That is, we will not go into the merit of it. Yes. This is still 7, correct? Yes, still 7. Except the work order and the amount. Yes, Mr. Ejmami.
Short question here, Your Lordship.
Yes.
Constitutional mandate of Article 300A, and then the prescriptions of the National Highway Act 1956.
Okay.
Yes, sir. Yes, sir. So damage compensation is actually a part of the acquisition.
Okay.
Actually a part of the total compensation. But they have split it up into damage compensation and land compensation. Damage compensation is being paid, but no land compensation.
No land compensation. Hegemony. The Corporation Limited, LDT, within bracket NHIDCL, began the process of building NH 129 capital A. Stop. The entire stretch of the highway was divided into 5 packages and NITs were issued for each of them. Stop. The petitioners are from Jaluki B village and their land falls under package 2. Yes. Stop. It is the case of the petitioner that during the initial stage of the project, meetings were held between the NHIDCL, state government, and the representatives of the village council of the village, situated on the route, ROUTE, of the said highway. Stop. On the basis of the meetings, landowners like the petitioners were informed that apart from damage compensation, no land compensation would be paid for the land acquired for the construction of NH
For the
120.
land taken, Your Lordship, not acquired, taken. Acquisition process has never happened.
For the land taken, for the land taken for the construction of NH 129A. Stop. It is the case of the petitioner that denial of the compensation as such. A legal notice dated 8/8/2023 was served to the respondents. Stop. By the letter dated 30/8/2023, the Union of India and the NHIDCL responded to the legal notice and stated that the government of Nagaland, by letter dated 6/8/2020, has provided land free of cost for construction of 2 land projects in the state. The letter also referred to the no objection certificate issued by the village councils and the acceptance of damage compensation by landowners. Stop. Individuals slash families and clans. And the village council has no authority to grant slash transfer slash convey land without the express consent of the landowners. Stop. In the instant case, the petitioners did not authorize the village council to grant slash transfer slash convey their land for the construction of NH 129A. It is further submitted that the fact that the petitioner the way for receipt of just compensation for the land taken over by the respondents. Okay? It is further the case of the petitioner that the right to property is protected by Article 300A of the Constitution of India, and matters relating to national highways is governed by the provisions of the National Highways Act 1956. The acquisition of land by the central government is governed by the right to fair bracket, requisition and acquisition, close bracket, Act 1965. Therefore, it is therefore submitted that in order to take the land of the petitioner for the construction of NH 129A, the respondent must comply with the aforesaid constitutional and statutory provisions. The deprivation of the petitioner's land in violation of the constitutional and statutory prescription is impermissible in law. The none.
Yes, sir.
Government?
I have served copies there, but no one appears to be either for the union, central state also. Yes, we have served copies to the state also. KB, Mr. KMOE.
Oh,
The union respondents are 1.
yes.
Initially sale is 2 and 3. And the state is from 4
Okay.
to 8.
Issue notice, returnable within 4 weeks. Since Mr. M.S. Livika, the learned government advocate, appears on behalf of the respondent number 4, 5, 6,
to 8 years.
7, and 8, no formal notice need be issued.
9 by registered.
The learned counsel for the petitioner shall however serve the requisite copies of the writ petition to the learned state council within
Within 2 days.
a period of 2 days from today. Insofar as the respondent number 1, 2,
3 and 9.
1, 2, 3, and 9 is concerned, the learned counsel
By registered person.
the said respondents by registered post with AD within a period of
2 days.
2 days. Listed accordingly.
Not intended on the returnable date. This is
Well,
not clear because
well,
the
what is
land
the-
has to be surveyed now. Because the character of the land itself will change. So the land has to be surveyed vis-a-vis its earlier position.
Have you sought for that relief?
Yes, no. It's there in the interim period at page 22.
The interim prayer for directing the respondents to survey the land of the petitioner taken for the construction of NH 129 in package 2 shall be considered on the next returnable date.
Much better.
For motion, item number 9.
And, Your Lordship, this is again one of those peculiar cases. Joint GB's court issued an order on the basis of the respondent's application. We submitted a complaint to the village council. Village council endorsed it to the Dubashi's court directly. Dubashi's court passed an order saying that earlier during the visit of the ADC, ADC administration, the direction was that if you want to receive benefits from the government, both villages should have only one village council, one chief. That position still obtains. But in the village, Yangtze B village, there is a dispute between 2 sides as to who is the chief. But that dispute needs to be resolved.
Okay. Mr. A. Jimubu, the learned counsel for the petitioner. Stop. New para. The present application has been filed. Of India, invoking the supervisory jurisdiction / powers of to question set aside the settlement order dated 29/1/2004 passed by GB's board, comma, Yang Zitong, and the settlement dated 16/4/2004 passed by DB's court, Srichung district,
Kifre.
district, district Kipri, and to permit the petitioner to take appropriate steps before the court of competent jurisdiction to adjudicate and settle the dispute to chieftainship in Yangzitong B and
This Yangzitong B village was earlier known as
Okay. Yangzitong B village. Okay. Stop. It is the case of the petitioner that in terms of the rules for administration of justice and police in Nagaland, 1937, the JB's board, Yangzitong A and Yangzitong B village has no power / jurisdiction to decide the dispute between the petitioners representing Stop. It is further the case of the petitioner that with the separation of the judiciary from the executive and the adoption of the Nagaland Judicial Service Rules 2006, 2006, judicial courts have been established. Stop. However, there is a disconnect between the customary courts functioning under the rules of 1937 and the customary courts function and the judicial courts. Stop. This issue has been referred to the Honorable Chief Justice by the judgment and order dated 05/2020. Stop. It is the case of the petitioner that in the given circumstances, the petitioners are approaching a court with competent jurisdiction in relation to the dispute of chieftainship in Kukikle / Yangzitong B village. And for that purpose, the settlement of GB's board, Yangzitong A and Yangzitong B, dated 29/1/2004,
28/1, my lord.
29/1/2004, and the settlement order dated 16/4/2004 of the Dubashis Court may operate as obstacles and therefore may operate as obstacles. Stop. Therefore, the present petition. Issue notice to the respondents, returnable within 4 weeks. MSAIME represents the state respondents?
Number one.
Respondent O, respondent number,
One.
okay. Respondent number 1. Therefore, no formal notice need be issued to the state respondents. The learned counsel for the petitioner shall however serve requisite copies of the writ petition to the learned state counsel
During the course of the day.
in the course of the day. Stop. Insofar as the respondent number 2, 3 and 4 are concerned, the learned counsel for the petitioner shall take steps for service of notice upon the said today, 2 days from today, listed accordingly.
Much obliged.
For motion, item number 12.
Yes, Mr. Lima.
Yes, Lordship, the decision is challenging the order dated 10/11/2022. Lordship, we just annex it, page 24, annexure 7.
Then this will say, yeah,
Initially, Lordship, but before the
acceptance.
acceptance, I have submitted a letter for withdrawal.
Okay, but
Without considering that, you have issued this internal.
Mr. Lima Wabang, the learned counsel for the petitioner. White order dated, that white order dated 3/2/1999. The petitioner was initially appointed as a primary teacher on ad hoc basis at Government Primary School, Sirmi, under the establishment of
Respondent number 3, Lordship.
under the establishment of the subdivisional, correct? Subdivisional Education Officer, Zineboto, Nagaland. Stop. Thereafter, pursuant to the recommendation made by the District Selection Board, the ad hoc service of the petitioner was regularized by order dated 3/3/2021. Stop. While in continuous service, the petitioner, for personal reasons, tendered the letter dated 31/10/2007, resigning from service. The resignation letter of the petitioner was however not accepted by the authorities, and in the meantime, the petitioner again submitted the letter dated 30/3/2021 to the respondent number 2, withdrawing his resignation. Stop. However, the respondent number 2, via impugn order dated 10/11/2022, accepted his resignation with retrospective effect from 31/10/2017. Stop. It is the case of the petitioner that the action of the respondent number 2 is not sustainable present writ petition. Issue notice to the respondents, returnable within 4 weeks. Mr. So-and-so appears for the state respondents, therefore no formal notice need be issued. Stop. The learned counsel for the petitioner shall however serve the requisite copies of the writ petition to the learned state counsel within
2 days, right?
a period of 2 days from today, listed accordingly.
For admission, item number 11.
Yes,
Your Lordship, I need to receive instruction, Your Lordship, so sometime will be given.
okay. MS Livika, The learned government advocate seeks for 3 weeks' time to file affidavit in opposition. Prayer is allowed, listed accordingly.
What's the place?
For admission, item number 12.
Your Lordship, I have a similar to your Lordship. I'm here to receive instruction.
Who's for the petitioner? Ma'am, you are for the petitioner?
Yes, Your Lordship.
For the petitioner?
Yes, Your
Okay,
Lordship.
same order. Same order.
Lordship, Lordship.
Yes.
For admission, item number 13.
Yes, ma'am.
Your Lordship, here I'm here to receive instructions. So when he's up
Who is for the petitioner? Ma'am, I hope you are not forgetting your case. MS Inauli. Of Mr. E. Tibapom, the learned government advocate, and 6 for 3 weeks' time to file affidavit in opposition.
For admission, item number 15.
Yes, Your Lordship.
Yes.
I'm praying on behalf of K. Gandhi, Your Lordship.
Okay.
Here, he's here to receive instructions. So when sometime, Your Lordship.
Okay, ma'am. MS Inaholi makes a mention on behalf of Mr. N. Angami,
K. Angami, Your
K.
Lordship.
Angami, the learned senior government advocate, and seeks adjournment of the case for 3 weeks to file affidavit in opposition.
Lordship, there is an injury.
Okay, prayer is allowed, listed accordingly. Stop. The inter continue till the next returnable date. Okay.
Lordship, like- Please.